So firstly, we will understand the meaning of labor legislations. The term labor means the workforce who works for compensation, and legislation means law which has been enacted by a legislature or other governing body. Thus, labor legislation means rules made by the governing body for the protection of labor. Various types of laws enacted by different governing bodies are Industrial Employment Standing Orders Act 1946, Factories Act 1948, Industrial Disputes Act 1947, Trade Unions Act 1926, Child Labor Prohibition and Regulation Act 1986, the Apprentices Act 1961, Employment Exchange Act 1959, Maternity Benefit Act 1961, Contract Labor Regulation and Abolition Act 1970. We will discuss here one by one. After studying this lesson, you will be able to discuss the major provisions and related concepts of Industrial Employment Standing Orders Act 1946, Factories Act 1948, Industrial Disputes Act 1947, Trade Unions Act 1926, Child Labor Prohibition and Regulation Act 1986, the Apprentices Act 1961, Employment Exchanges Compulsory Notification of Vacancies Act 1959, Maternity Benefit Act 1961, Contract Labor Regulation and Abolition Act 1970. So let's start with the first act, Industrial Employment Standing Orders Act 1946. The object of the act is to have uniform standing orders providing for the matters enumerated in the schedule to the act for those who are employed before and those employed after the standing orders came into force. For submission of draft standing orders, the employer shall submit to the certifying officer 5 copies of the draft standing orders proposed by him within 6 months. Provision shall be made in such draft for every matter set out in the schedule which may be applicable to the industrial establishment. The draft standing orders submitting under this section shall be accompanied by a statement giving prescribed particulars of the workmen employed in the industrial establishment, including the name of the trade union, if any, to which they belong. For certification of standing order, on receipt of the draft under Section 3, the certifying officer shall forward a copy thereof to the trade union, if any, of the workmen to make to the draft standing orders to be submitted to, after giving the employer and the trade union or such other representatives of the workmen within 15 days from the receipt of the notice, an opportunity of being heard, the certifying officer shall decide whether or not any modification of the draft submitted by the employer is necessary to render the draft standing orders certifiable under this act. After being satisfied, modifications are done finally and the copies are distributed to necessary parties. Standing orders shall be certifiable under this act if provision is made therein for every matter set out in the schedule which is applicable to the industrial establishment. The standing orders are otherwise in conformity with the provisions of this act. Now let's discuss the second act, that is Factories Act 1948. The Factories Act is a social legislation which has been enacted for occupational safety, health and welfare of workers at workplaces. It applies to factories covered under the Factories Act 1948. The industries in which 10 or more than 10 workers are employed on any day of the preceding 12 months and are engaged in manufacturing process being carried out with the aid of power, or 20 or more than 20 workers are employed in manufacturing process being carried out without the aid of power, are covered under the provisions of this Act. Salient features of the Act are approval of factory building plans before construction or extension under the Delhi Factories Rules 1950, grant of licenses under the Delhi Factories Rules 1950, and to take action against factories running without obtaining license. Renewal of licenses granted under the Delhi Factories Rules 1950 by the Deputy Chief Inspectors of Factories. Inspections of factories by District Inspectors of Factories for investigation of complaints, serious or fatal accidents, as well as suo motu inspections to check compliance of provisions of this Act relating to health, safety, welfare facilities, working hours, employment of young persons, annual leave with wages, etc. The enforcement of this legislation is being carried out on district basis by the District Inspectors of Factories. After inspection, improvement notices are issued to the defaulting managements, and ultimately legal action is taken against the defaulting managements. The inspectors of factories file challans against the defaulters in the courts of metropolitan magistrates. The work of inspectors of factories is supervised by the Deputy Chief Inspector of Factories on district basis. And if we talk about penalties, then this Act provides for a maximum punishment up to 2 years or a fine up to ₹1 lakh or both. Now let's look into Industrial Disputes Act 1947. This Act extends to the whole of India. It came into force on the first day of April 1947. The purpose of this Act is to settle industrial disputes, to prevent illegal strikes, to provide compensation to workers in case of layoffs, retrenchment and unit closure, to promote collective bargaining, to ensure social justice. Its applicability to any industry unit regardless of the numbers of workmen employed. A workman means skilled, unskilled, manual labor, technical, clerical and supervisory workmen, but excludes supervisory workers having a salary of more than ₹1,600 per month. Authorities under the Act are Work Committee, which is a committee in every industrial establishment having 100 or more workmen. Conciliation Officer, whose role is to mediate and promote the settlement of industrial dispute. If this fails, then the Act provides for labor courts, district and state tribunals and national tribunals for the adjudication of the dispute. Its important provisions are: the Act makes it obligatory for the employer to give a notice of change before effecting any changes in the conditions of service in respect of matters such as wages, leave and holidays, introducing new rules of discipline, withdrawal of concession or privileges. A 21 days notice has to be given to all such workmen who are likely to be affected by these changes. The Act provides for providing full wages for workers during the pending order of dispute in High Court or Supreme Court. Every award or settlement arrived during the settlement machinery is binding on all parties to the dispute, legal hires, and all present and future employees. A dismissed workman is also covered under the Act. Lay-off compensation at the rate of 50% of basic plus DA, and for retrenchment at the rate 15 days wages for every completed year of service with a minimum service of 1 year. Layoff means failure, refusal, or inability of employer on account of shortage of coal, power, or raw materials, or accumulation of stock, or breakdown of machinery, or natural calamity to give employment to a workman on a must. Fourth one is the Trade Unions Act 1926. In the year 1925, the Government of India, after consulting the state governments, drew up a bill providing for the registration of trade unions and introduced the same in the Legislative Assembly on the 1st of August 1925. The Indian Trade Union Act was passed in 1926 and came into force on 1st of June 1927. As per this Act, trade union means any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relations between workmen and employers or between workmen and workmen, or between employers and employers, or for imposive, restrictive conditions on the conduct of any trade or business. It includes federation of two or more trade unions. The Act extends to the whole of India and includes all unions and associations of workmen. Provisions under the Act are: registration of trade unions requires 7 or more members of a trade union to make an application to the registrar. The application should have the names, occupations, and addresses of the members and the office bearers, name and address of the trade union. A certificate of registration is issued by the Registrar of Trade Unions on registering a trade union, which shall be conclusive evidence that the trade union has been duly registered. Appeal. Any person aggrieved by any refusal of the registrar to register a trade union can appeal in the High Court within 60 days from the date of such refusal. Every registered trade union becomes a corporate body and is required to create separate funds for general purposes and a separate fund for political purposes. Notification of change in the address of the head office should be given within 14 days of such change to the registrar in writing. Now the topic is Child Labour Act 1986. The objective of the Act prohibits employment of child who has not completed 14 years in all the occupations indicated in Part A of Schedule to the Act and in all processes indicated in Part B of the Schedule to the Act. It extends to the whole of India. Under this Act, child means a person who has not completed his 14th year of age. The central government has the power to amend the schedule. For this, the central government, after giving notification in the official gazette, not less than 3 months' notice of its intention to do so, may by like notification add any occupation or process to the schedule, and thereupon the schedule shall be deemed to have amended accordingly. Important provisions under this Act are: prohibition of employment of children in certain occupations and processes. The central government may form a child labor technical advisory committee to advise the government on the additions of occupations and processes. The Act stipulates the hours of work for different types of processes and occupations for a child worker. A child cannot be given overtime working, and weekly holidays shall be given to him. Employer should maintain separate register for child workers in permitted establishments regarding name, age, nature of work, hours of work, and rest periods. This can be inspected by appropriate bodies. Contravention of the provisions of the Act calls for imprisonment for at least 3 months, which can be extended to 1 year, or with a fine which shall not be less than Rs 10,000, which may be extended to Rs 20,000, or both. Second conviction calls for an imprisonment of 6 months extendable to 2 years. Slide 9. Now let's discuss Apprenticeship Act 1961. It extends to the whole of India. It shall come into force on such date as the central government may, by notification in the official gazette, appoint, and different dates may be appointed for different states. The Act aims at preparing young citizens as skilled craftsmen through the joint efforts of the employer and the apprentice. The main purpose of the Act is to provide practical training to technically qualified persons in various trades. The objective is promotion of new skilled manpower. The scheme is also extended to engineers and diploma holders. Provisions of the Act includes: apprentice. The person should not be less than 14 years of age and should satisfy the standards of education and of physical fitness as may be applicable to different trades and industries. Apprentice contract. Before undergoing any apprenticeship training, there should be a contract between the employer and the person intending to be engaged as an apprentice. In case of minor, the guardian has to enter into contract with the employer. The employer has to send the contract to the apprenticeship advisor for registration within 3 months of signing the contract. The contract is valid only on registration. Duration of the apprenticeship training will be decided by national or state councils. It is mandatory for the employer to grant a certificate of training to the apprentice on his successful completion of the training period and subsequent tests. On completion of training, every trade apprentice has to appear for a test conducted by National Council. If he passes, he gets a certificate of proficiency. The provisions of this Act shall not apply to any area or to any industry in any area unless the central government by notification in the official gazette specifies that area or industry as an area or industry to which the said provisions shall apply with effect from such date as may be mentioned in the notification. Any such special apprenticeship scheme for imparting training to apprentices as any be notified by the central government in official gazette. Any offence by employer under this Act is punishable with imprisonment up to 6 months. Now let us look at the Employment Exchanges Compulsory Notification of Vacancies Act 1959. It extends to the whole of India. It shall come into force in a state on such date as the central government may, by notification in the official gazette, appoint in this behalf for such state, and different dates may be appointed for different states or for different areas of a state. The Act shall not apply in relation to the following vacancies: in any employment in agriculture and horticulture, employment in domestic services, where the employment is for a duration not exceeding 3 months, any type of unskilled work, any vacancies to be filled by internal promotions, in any employment connected with staff of Parliament, vacancies where the remuneration is below ₹60 per month. If any employer fails to notify to the employment exchanges prescribed for the purpose any vacancy in contravention of subsection 1 or subsection 2 of section 4, he shall be punishable for the first offence with fine which may extend to 500 rupees, and for every subsequent offence with fine which may extend to 1000 rupees. Now let us look at the Maternity Benefit Act 1961. It extends to the whole of India except the state of Jammu and Kashmir. It applies in the first instance to every establishment being a factory, mine or plantation, including any such establishment belonging to the government. The purpose is to regulate the employment of women in certain establishments and for certain periods before and after childbirth, and to provide for maternity benefits. Provisions under the Act are: to be eligible for maternity benefits, a woman must have worked for not less than 80 days in the 12 months preceding delivery. Maximum period of maternity benefits is 12 weeks. 6 weeks pre-delivery and 6 with post-delivery. In case of illness arising due to miscarriage, etc., women can take extra leave with wages up to a maximum period of 1 month in addition to the 12 weeks of maternity benefit. A woman employee can ask for light work for 1 month preceding the 6 weeks prior to delivery, etc. If any employer contravenes the provisions of this Act or the rules made thereunder, he shall be punishable with imprisonment, which may extend to 3 months, or with fine, which may extend to 500 rupees or both. The last is the Contract Labour Act 1970. It extends to the whole of India. It applies to every establishment in which 20 or more workmen are employed or were employed on any day of the preceding 12 months as contract labor. It shall not apply to establishments in which work only of an intermittent or casual nature is performed. Provisions under the Act are: a workman is deemed to be employed as contract labor in or in relation to work of the establishment if he is hired for such work or through a contractor with or without knowledge of principal employer. If a principal employer or the contractor falls within the vicinity of this Act, then Such principal employer and the contractor have to apply for registration of the establishment and license respectively. Principal employer has to apply for registration in respect of each establishment. The Act also provides for temporary registration in case the contract labor is hired for a period not more than 15 days. Whoever contravenes any provision of this Act shall be punishable with imprisonment for a term which may extend to 3 months, or with fine which may extend to 1,000 rupees, or both, and in case of a continuing contravention with an additional fine which may extend to 100 rupees for every day during which such contravention continues after conviction for the first such contravention. Now let us check if we have understood the various concepts discussed in this lesson clearly. For submission of draft standing orders, the employer shall submit to the certifying officer copies of the draft standing orders within 6 months. Right or wrong? Right. Any offence of Apprentice Act by employer under the Act is punishable with a fine of rupees 1,000. Right or wrong? Wrong. Under the Child Labour Act, child means a person who has not completed his 14th year of age. Right or wrong? Right. Now let's revise the whole concept. The Industrial Employment Standing Orders Act was introduced to have a uniform service condition for the workmen employed in all industrial establishments. The object of the Factories Act is to ensure for the workers employed in the factories health, safety and welfare measures and to provide for proper working hours, leave and other benefits entitled to them. The Industrial Dispute Act was set up to prevent industrial disputes like strikes and lockouts and to promote collective bargaining. Trade Unions Act was passed to regulate and govern the activities of a trade union. The Act extends to the whole of India and includes all unions and associations of workmen. The Child Labour Prohibition and Regulation Act lays down a procedure to decide modifications to the schedule of banned occupations. The main purpose of the Apprentice Act is to provide practical training to technically qualified persons in various trades. The purpose of the Maternity Benefit Act is to regulate the employment of women in certain establishments and for certain periods before and after childbirth and to provide for maternity benefits. Thank you.